Hello, everybody. Today we'll be covering the Supreme Court decisions and expectation of privacy section of 2.2.2. In this section, we will explore Supreme Court's decision concerning privacy and new technology in 4 example cases. The first case, Olmstead v. United States in 1928. The second case, Katz v. United States in 1967. The third case, United States v. Miller in 1976. And the last and most recent case, Kyllo v. United States in 2001. In the Olmstead v. United States case of 1928, the government used wiretaps on the telephone lines without court order. The Supreme Court ruled the Fourth Amendment only applied to physical intrusion and search or seizure of material things. The Supreme Court ruled in favor of the United States and allowed the wiretaps. After the trial, Supreme Court Justice Louis Brandeis argued that the authors of the Fourth Amendment were doing all that they could to protect liberty and privacy, including private conversations from intrusion from the government based on the technology at the time. In the Katz v. United States case of 1967, law enforcement agents attached an electronic listening and recording device on the outside of a telephone booth to record a suspect's conversation. The Supreme Court deemed the Fourth Amendment protected people and not places. They believe the government agents should need a court order to intrude in places where a reasonable person has a reasonable expectation of privacy. An issue with this is what reasonable expectation of privacy with growing advances in technology could mean. In the United States v. Miller case in 1976, Mitch Miller was accused of not paying taxes. The ATF requested bank records from 2 of Miller's accounts. The Supreme Court ruled that if we share information with businesses such as our bank, then we have no reasonable expectation of privacy for that information. When we share information with banks, websites, apps, or search engines, what level of privacy do we expect? In the Kyllo v. United States case in 2001, police used thermal imaging devices to search a home from the outside without a search warrant. The Supreme Court deemed that the surveillance is a search if the government is using a device that is not in the general public's use to explore details of a home that previously would not have been known without physical intrusion. The Supreme Court ruled that police could not use the thermal imaging devices to search a home from the outside without a search warrant. A problem with this ruling is government being able to use surveillance equipment depending on its public accessibility and popularity. There are some things to consider from this section, like should law enforcement use technological advances to aid in finding and catching criminals? Should the government have to get a warrant to use new technology to search a person? And is that affected whether the person is in a private area like their home or a public area like a park? How would you interpret the Fourth Amendment with growing technology? And to what extent is a business or company sharing your private information versus company records?